Good evening, ladies and gentlemen. Welcome to the NUS Law School and this distinguished visitor lecture hosted by the E.W. Barker Center for Law and Business. My name is Hans Tjio. I'm the director for the E.W. Barker Center for Law and Business. We're extremely pleased and privileged to have with us today Professor Marc Steinberg, who is the Rupert and Lillian Radford Chair in Law at the Southern Methodist University Dedman School of Law. Notice that I did not say SMU, which is actually how it's known in the US. That's because I don't really want to advertise one of our rival institutions in Singapore, but it looks like I've done that anyway. But Professor Steinberg tells me that actually they do call themselves SMU, and they don't actually call themselves Southern Methodist University in the US. Professor Steinberg is very well known to us in the securities regulation world through his many writings which engage with practice more than some of the more abstract writings that we have today. Judges around the world have commented on how they find modern academics much less useful than those in the past. This is not to suggest that Professor Steinberg is of such a different vintage. He'll tell you that he's only, I think, 45 at the moment. But it does reflect the fact that he started out his career not as an academic, but as an attorney for the US Securities and Exchange Commission in the SEC's Division of Enforcement, and then later on the Office of General Counsel. Because of that, he is in high demand, and I think that is why MES has him there next week to speak in-house, which also explains why no one from the MES is here today. So if you have any questions that you feel is a bit sensitive, please ask, right? No one from the government is here today, I think. For me personally, his book on securities litigation is a constant companion when trying to understand things like class action litigation, forward-looking statements, materiality, or the truth on the market doctrine. These are all very practical things that you actually don't find modern academics talk about. It marries both doctrine and practice wonderfully well. His most recent book, Rethinking Securities Law by Oxford University Press, which was kind enough to give me today, was awarded the winner of the Best Law Book in the United States for 2021 by the American Book Fest. It is a timely call to action to relook the area of securities regulation altogether, and this is needed especially given how digital assets or crypto assets have disrupted the capital markets and its regulation. His talk today is of immense interest as it questions one particular aspect of US securities laws, and this is that insider trading is founded on notions of fiduciary duties and responsibilities, or perhaps some kind of misappropriation theory. Many countries, including Singapore, have moved to a parity of information approach, which frees us from the need to prove connections between the insider and the company and the information. What we do in Singapore, as Professor Steinberg will tell us, we focus on the possession of information and the knowledge that what you possess is inside information. Yet, we know that the US is not just a market leader, but it's also a regulatory leader normally. In 1999, for example, we adopted the treble damages regime for insider trading from the 1988 Insider Trading Securities Fraud Enforcement Act. The US was one of the first in the world to start using civil penalties in a large way. We do this as well now, but the strange thing, of course, is that the use of civil penalties has recently been dialed back by the US Supreme Court. Professor Steinberg will therefore explain to us how perhaps US regulations have slightly fallen behind the curve, even as US markets have boomed, and then what needs to be changed in the US going forward from a regulatory perspective. So welcome to Singapore, Professor Steinberg.
Thank you, Professor Tjio. Very much appreciate the invitation. Dean Semester, very much appreciated. There's many things good about the U.S. securities laws, and I better give a pretty good talk after that wonderful introduction, so hopefully I will. There are many good things about the U.S. securities laws, and many countries in the world follow key aspects of it. But one aspect which countries don't follow is the general law relating to U.S. insider trading. And the reason for that is that the U.S. securities law with respect to insider trading is muddled, it's inconsistent, it doesn't make sense in a lot of ways. I tell my students when they study insider trading that with respect to some of the issues, they can take their common sense and basically throw it outside the window because it's utterly lacking with respect to consistent and fair enforcement. Basically, insider trading in the U.S. is defined as one trading on material and non-public information. I gather that a number of you are experts who are here in the room, and a number of you are generally familiar but are not experts. So I will go through some basic issues. So hopefully this makes sense to all of you. So trading on material and non-public information. What is the definition of materiality? In many countries, I understand, including in Singapore, I'm not an expert in Singapore securities law, it very much focuses on whether that information has price impact. In the U.S., that inquiry is more generally focused upon with respect to causation issues, and not with respect to materiality. Generally, materiality is defined as it is here from an initial standpoint, and that is a fact that would assume importance to a reasonable investor, a fact that would assume importance to a reasonable investor. It does not have to be outcome determinative. An investor does not have to say, if I had known that information, I would not have purchased the security. It's simply information that would assume to be important to a reasonable investor, an objective standard. Well, what does that mean in factual context? Let me give a couple examples. One is with respect to contingent events, such as whether merger negotiations will in fact result in the consummation of a merger, for example, or whether contract negotiations with respect to a major undertaking will in fact end in a deal. Another example is whether a preliminary mineral fine will bear out what its initial findings were, that it was a very impressive mineral find which will redound to the economic benefit of the company. That's how it's used, and the general perspective is the greater the magnitude, the less the probability. The greater the magnitude, the less the probability. Well, that sounds fine, but what does that really mean? So let me go through what I go through when I teach my class on this, or when I talk to attorneys who are not all initiated and well-schooled in securities law. What I have in my pocket here is a $2 bill, Singapore dollars, $2. And let's suppose, I don't know how many people are here, but let's suppose there are 35 people here at the present time. I'm just waiting for the other 60 people to come, but we'll see if they do or they don't. They're missing out on hopefully a good talk. We'll see if you agree. So the situation is that I've got a $2 Singapore bill here, and come tomorrow morning at 9 o'clock, everybody's name will be put in a hat, and I will come in and pick someone's name out of the hat, and that person will win $2. Now, the rules is that each one of you must stay here all night long. You can bring in refreshments. You can order some pizza or whatever cuisine you like. You can get a friend to drop off a pillow and a blanket, but you've got to stay. And of course, you can use the restroom, but you've got to stay here all night long. And in the morning, tomorrow morning, one of you will win $2, okay? So each one has roughly a 3% chance of winning. How many of you will likely stay? I think no one. Okay. Now let's suppose, for those of you who are not students, that you were students. So you have a lot of bills to pay. You may have some loans. You're trying to make your apartment payments, whatever. And instead of this being $2, this is a check made out to the winner for $2 million Singapore dollars. 2 million Singapore dollars. Same rules. You have to stay the night. You can order a pizza. You can bring a pillow with you if you want, and in the morning, I will draw the winner of the hat, and one of you will be awarded 2 million Singapore dollars. I have a feeling that many of you would stay around. So here we have a very small percentage, 3%, and yet the magnitude is huge. And under U.S. law, that would be clearly material. And we have some very, very expert legal counsel here tonight. And the counseling, and perhaps this is the case here in Singapore as well, being able to counsel one's client from a transactional viewpoint and from a preventative law viewpoint with respect to what facts are material can be one of the toughest issues that a securities lawyer counsels on. Is that the case here as well? At times, well, you can imagine with the issue of materiality, that's certainly the case in the United States. So that's one example. The other example was qualitative economic materiality. So what that deals with is that even a very small amount, such as 1 or 2 cents with respect to a company's earnings, would be deemed to be material. So what happened 20 years ago, 25 years ago, is that companies were involved in what was called earnings management. Critics would call it fudging the books, they would call it managing earnings, and the SEC called it fraud. And what was involved in is, let's assume that the economy is good, there are not labor problems, inflation is under control, employment is good, and a company enjoys its best fourth quarter. We're in the fourth quarter now, at least on an annual fiscal year. The company enjoys the best fourth quarter that it has achieved, and it surpassed analyst forecasts, let's suppose by 6 cents, 6 cents per share. Is cents used here in Singapore, the term cents? Okay, thank you. I'm learning. So 6 cents per share. And in other words, analysts forecast that the company would earn 30 cents per share that quarter, and the company, in fact, made 36 cents per share. Well, what the company said, and any of you play golf? What's your best score you ever had, sir?
About 95.
95. And what do you usually shoot?
Sorry?
What do you usually shoot? What do you shoot on a normal day?
Over 100.
Over 100, okay. So can you believe I once taught a student who shot a 59 for 18 holes in a pro tournament, and it was awarded what is called the Ben Hogan Award for the best collegiate golfer in the United States. Ben Hogan was a great U.S. golfer. So let's just say you usually shoot 105. Let's just say that. I would shoot 105 for 9 holes myself. The last time I played golf, my son and I purchased 15 golf balls at the beginning of the round, and we had to stop on the 8th hole because we were out of balls. So that says something about my golf game. So it was mostly me, not my son. So let's suppose that when you shot a 95, I imagine, for the quality of your game, a lot of things went right that usually do not. You may have not hit the sand traps, you made some putts you don't usually make, and you walk off the green, you're proud of yourself, you did great, and now you're told, now every time you play from now on, you've got to shoot a 95. Well, that's the concern with analyst forecasts. So the company says, we can't make this percentage every single quarter. Let's simply declare that we made 32 cents this quarter. So therefore, we surpass the analyst forecast and our stock will go up. We'll take the other 4 cents and basically put it in our bank. So that if we're short a cent, in other words, the next quarter, if the analyst forecast will make 25 cents per quarter, and we make 24 cents, we can simply take a penny out of our bank and use that to meet analyst forecasts. So that was what was happening in the United States. And that's impermissible. And that's where the term qualitative economic materiality came in. And that is, even though the overstatement may be a very small percentage, such as 2% or 3%, if it has the effect of meeting analyst forecasts or triggering executive bonuses that certain standards were required to be met, then that situation is material. So even very small statements can nonetheless be material. So that's generally the meaning of materiality. What about non-public? In the U.S., information can be non-public even though there are rumors in the marketplace, very strong rumors in the marketplace about a particular event, such as whether a merger will occur. That's generally what the principle is in the United States. Yet, the SEC takes the position that information does not become public until one of two things happens: that the information is adequately disseminated to the public marketplace. And how does that ordinarily happen? That happens by the company generally releasing a press release and at the same time filing what is called a Form 8K current report with the U.S. SEC attaching that press release as an amendment to the Form 8K. So that's the normal way that information becomes public. The other way is that even though the information has not been publicly disclosed by the company and disseminated, nonetheless, that information has been revealed to institutional and other active investors, and that information has been fully impounded into the market price of the stock. As you can imagine, that's a much more difficult standard to meet, because in that situation, you've got to have economists providing expert opinions and so on, that in fact that information flowed through entirely to accurately set forth what the market price is. So that's material and non-public information. Now let me talk about the law of insider trading. That the Federal Securities Acts were passed in 1933 and 1934 in the U.S. They were passed in the midst of the Great Depression, and these acts were the first enactment of consumer protection legislation in the United States. And what happened is that insider trading, other than what's called the short swing trading, whereby insiders must disgorge their profits if they purchase and sell or sell and purchase within a 6-month period, all that was within the duty of loyalty under state company law. The problem was that the states, each state in the United States, there are 50 states, have their own state company law. The states did not adequately oversee insider trading with respect to the stock exchange trading. And in 1960, President Kennedy nominated Professor William Carey, who was a Columbia law professor, a Columbia University law professor, to be chair of the SEC. Professor Carey was outraged that insider trading was not adequately enforced, and he went looking for an insider trading case. And in 1961, the SEC found one and brought a case that's called the Katie Roberts case, basically adopting the access approach. That was the position of the SEC, but nonetheless, no federal court had adopted that situation. It was not until 7 years later that the Texas Gulf Sulphur decision was decided by a U.S. appellate court. And that decision is, in fact, in my view, perhaps the most important decision in U.S. securities law. And why do I feel that way? Because the decision deals with so many diverse issues, many of which are still good law in the U.S. and which have been adopted by other foreign countries. For example, that decision adopted the parity of information approach, which many countries around the world have adopted, including Singapore, I understand. That decision dealt with the term materiality. It dealt with a company's liability with respect to secondary market disclosures. It dealt with when tippees can be liable, those who receive inside information. So it dealt with a host of issues. And what that case involved was a great mineral ore find in Ontario, which is a province of Canada. And this was a preliminary fine, but for a preliminary fine, it was a 10 out of 10. It couldn't have been better. And the insiders of the company, the attorney for the company, the geologist for the company, they all bought additional shares in the company, and many of these individuals bought options when they had never bought an option before in their life. The SEC brought suit, and the defense was this was a preliminary fine. The information was not material. It was much too speculative. And just to show how important the case was, once the district court decided the case in favor of the defendants, the U.S. Court of Appeals for the Second Circuit, which is located in New York, took the case en banc, which means the entire court decided the case. What happens in the U.S. is that the appellate court sits in panels of 3 judges. And for instance, an appellate court may have 12 judges, but they only sit in panels of 3 unless they take the case en banc. And normally what happens is that a panel decides the case of 3 judges, and then if petition is made for the court to rehear en banc, the judges vote to rehear en banc. In this case, and I'm not familiar with in other cases this happened, the Second Circuit dispensed with a panel decision and went straight to an en banc decision. And there the court said that this was a violation of the insider trading laws, basically Section 10B of the Securities Exchange Act of 1934, which is the principal anti-fraud remedy of the securities laws in the U.S., adopted the standard of materiality, adopted the parity approach, and basically looked at materiality from the standpoint of the probability magnitude test I talked about, and also how did those who were privy to the information react to it. How a person reacts to the information is a good indicator whether the information is material. And here you had individuals buying stock in proportions that they never had purchased before, purchasing options when they had never purchased options before, and that added to the court's determination that the information was material. So for approximately 12 years after that decision, the law in the U.S. was like Singapore's law, and that is if one was in possession of material non-public information, having reason to know that that information came from an inside source, directly or indirectly, one could not trade in that information, and one could not convey, or what is called in the U.S., tip that information to others. Well, that all changed in 1980 when the U.S. Supreme Court adopted this case called United States versus Chirillo. And this was a bad case for the government to bring a criminal case. In other words, U.S. insider trading law was all civilly prosecuted by the U.S. Securities and Exchange Commission. No one went to prison for it. People may have disgorged their profits, they were subject to an injunction, but they did not go to jail. So you would think that the government would focus on a greedy insider, an officer or director, for its first case. And I don't know if it happens here, but at times the government does not choose wisely in the cases that it decides to prosecute. Well, the criminal cases are brought by the U.S. Department of Justice in the United States, and they brought a criminal case against this individual. What happened was that he was a worker at a financial press where the disclosure documents were printed. So by looking at the disclosure documents, he was privy to inside information about prospective deals that had not yet been announced. He went out and purchased the securities. So obviously, he had inside information before the general public. He did not know how to use this information. He was very poor at it. He traded on 6 deals and made $30,000 US. I mean, that is a hard thing to do, to have inside information for 6 different mergers or tender offers and make only $30,000. Anyway, the government prosecuted him. The Second Circuit upheld his conviction and went to the Supreme Court. And I remember I was working at the SEC at this time as an enforcement attorney. And we were astounded by this decision. We had never heard of this theory that the U.S. Supreme Court adopted. And that is, the U.S. Supreme Court rejected the access theory, rejected the parity of information theory, and premised Section 10B liability on principles of state law fiduciary duty. And basically, the law in the U.S. is that fraud based on silence is not actionable unless there's a duty to disclose. And a duty to disclose is required only when there is a fiduciary relationship or relationship of trust and confidence. And because Chirella did not owe a fiduciary duty to the sellers of the securities that he purchased, in other words, those individuals who were shareholders of the target companies, therefore he was not liable under Section 10b. So we had never heard of this fiduciary duty theory, and yet it has become the law in the United States. Now, what developed after Chirella was that the SEC, and this is the first example of the very haphazard regulation, the SEC was very unhappy with the Chirella decision. And what the commission did was look to the situation in the 1980s where insider trading was most abusive. And that was in the context of tender offers. For those who don't know what a tender offer is, that is basically where a prospective bidder makes an offer directly to the shareholders of the target corporation. In the United States, it is the one form of hostile acquisition that can be effective over the opposition of the target's board of directors and its management. So therefore, those were the deals in which high premiums were paid, and there's a provision in the U.S. securities laws called Section 14E, and the SEC adopted Rule 14E3. And what Rule 14E3 says is that anyone who knows or has reason to know and is in possession of material non-public information relating to a tender offer cannot trade or tip that information. So in other words, in every aspect of securities laws other than tender offers, the fiduciary duty approach applies. With respect to tender offers, that's the parity of information approach. So as I will illustrate in a few minutes, one can go to prison or keep one's profits depending upon whether an M&A transaction takes the form of a merger or a tender offer. And as we know, those engaged in trading on material and non-public information frequently have no idea what form the transaction will take. So the next situation that developed was, what about misappropriators, people like Chirella, who misappropriate information and trade with the shareholders with whom they owe no duty? The misappropriation theory is based upon breaching a fiduciary duty or relationship of trust and confidence to the source of the information. And there, the government found the perfect case, and that is a greedy attorney. I mean, what can be more perfect than that? And this case involved an individual named O'Hagan. O'Hagan was a partner in the Minneapolis firm, which is today a national law firm in the U.S., the Dorsey firm. The Dorsey firm represented Pillsbury. Pillsbury is in Minneapolis. That's a city in the U.S. It's very cold there in the wintertime. Pillsbury, perhaps they sell their products here. If you want to bake a cake, you can buy Pillsbury ingredients, and you can try your skills at baking a cake, something that I would not try myself, given my talent level with respect to that. What happened was the firm represented Grand Met. Grand Met was a company that was located in the United Kingdom, and Grand Met was going to make a takeover bid for Pillsbury. O'Hagan is walking the halls. He's not working in the deal. He's got open ears, and he's got to find a way to replenish his client's trust accounts because he had already misappropriated over $2 million of his client's funds for his own personal use. So he's probably figuring out, how can I replenish those accounts and maybe have some left over for myself? So he heard that information, and what he did was went out and he bought options and stock in Pillsbury. He knew what to do with inside information. He had inside information with respect to one transaction and made over $4 million. So he was very skillful at this compared to Chirella. The government brought a criminal case. It went to the U.S. Supreme Court, and the U.S. Supreme Court said, yes, we adopt the misappropriation theory. that O'Hagan owed a fiduciary duty to his law firm, the Dorsey firm, and to his law firm's client, Grand Met, and breached that obligation by using that information for his personal advantage. Now, here's another example of the bizarre aspect of U.S. securities laws. The U.S. Supreme Court said deception is how O'Hagan is liable, and if there's no deception, then there's no liability in the securities laws, so that if O'Hagan had disclosed to the sources of his information that he was going to trade prior to the time that he traded, there would be no violation. So that means today in the U.S., for U.S. securities law purposes, if O'Hagan had basically sent an email, let's suppose 3 hours before he traded, to his law firm and to Grand Met, I'm letting you know I'm trading on this inside information, and I hereby resign my position with the law firm, he could not be convicted of insider trading. So that's another aspect that one simply can scratch his or her head about, I think. So that's the misappropriation theory under U.S. law. Let me talk about tipping liability. Tipping liability used to be, as it is here in Singapore, as I understand the law in Singapore, and that is that one basically stands in the shoes of his or her tipper. In other words, if the tipper is an inside source and the tippee knows or has reason to know that the information comes from an inside source and is material, the tippee cannot trade either. That was the law in the U.S. That changed with the Dirks case. The Dirks case is another example of the government bringing a bad case. There's an adage in the U.S., if you have bad facts, you can get bad law. I don't know if it applies here in Singapore, but I think it probably applies universally. Well, that was a horrible case for the government to bring. What happened was, it was a company called Equity Funding. Equity Funding was really a predecessor, by way of example, to Enron. It was very well thought of in the securities markets. The company was in the business of writing life insurance policies as a core part of its business. The problem was that Equity Funding was writing life insurance policies on people who had already died or never lived on this planet. Raymond Dirks was a financial analyst at an investment banking firm called First Boston. He had heard rumors that this was happening. He went to the Wall Street Journal, he went to the California Department of Corporations, and they told him, Dirks, these are all rumors, leave us alone. Then Dirks found his source in a person called Seacrest, who was a former insider of Equity Funding. He got together with Seacrest. Seacrest introduced him to current employees of Equity Funding who confirmed this massive fraud. Before Dirks took this information to the government, he contacted his employer, who had its clients sell their Equity Funding stock before this information became public. Dirks thereafter made this information public through his firm, and the SEC commended him by bringing an insider trading enforcement action against him. And the theory, of course, was that Dirks learned this information from an insider, so therefore could not tip or use this information himself, which under the law as it stood was a correct interpretation. But at times, sometimes you balance the benefits versus the risks as a prudent enforcer in determining whether to initiate a case. The case goes up to the U.S. Supreme Court. The Supreme Court again adopts an interpretation which I personally had never heard of before its adoption, and that is that a tipper, meaning Dirks here, violates Section 10b by tipping only if he breaches his fiduciary duty by tipping. And one does so only if one tips for personal benefit or as a gift. And personal benefit ordinarily means financial benefit. Here, Dirks tipped to expose a financial fraud. He did not receive a personal benefit, so there was no liability. And note here that when the court talks about breaching a fiduciary duty, the court only looks to a fiduciary duty of loyalty, whether the person personally benefited. There's another fiduciary duty in the United States called the duty of care, and the court utterly neglects including the duty of care within this framework. So let me give some examples how this plays out. Any of you into U.S. collegiate football? A few? Well, I went to the University of Michigan undergrad. It's the largest collegiate football stadium in the country. It seats about 114,000 people. And they sell out the stadium. And collegiate football is huge in the United States. The school I currently teach at SMU has the 8th ranked team in the country. And the football coaches, for example, a very good football coach, collegiate football coach in the United States, I'm talking about college now, will make probably about $6 to $10 million a year. Far more than I make, I can assure you, and I write more footnotes than that football coach does, I can assure you. A few laughs, thank you. If I don't get a few laughs when I give a talk, I'm very disappointed. Thank you for doing that. So what happened was that Coach Switzer was the coach at the University of Oklahoma. Great football teams at that time. He was, in fact, the last coach of the Dallas Cowboys, the professional football team in Dallas, the last time the Dallas Cowboys won the Super Bowl. And I'm sure they show the Super Bowl here in Singapore. They show it all over the world if you want to watch it. Anyway, Coach Switzer, his son was competing at the track stadium at the University of Oklahoma. And Coach Switzer is a very, very friendly guy. I met him once. He likes to pat you on the back, shake hands, sign autographs. And he did that. He walked around, signed autographs. Then he saw Linda and George Platt. George Platt was the CEO of a company called TIC, which was traded in the New York Stock Exchange. TIC was the majority shareholder of its publicly held subsidiary, Phoenix, which was traded in the NASDAQ. In the U.S., it's not unusual to have a publicly held traded subsidiary of a parent company that is also publicly held. So Coach Switzer knew the Platts. The Platts company was a sponsor of Coach Switzer's television show, where Coach Switzer would receive additional revenue. And also, Coach Switzer had the Platts season tickets upgraded to the Oklahoma football games. So if you like to watch cricket, or if you like to watch what is football outside of the United States, or rugby, think of sitting behind the goal, and now you're sitting midfield. So in other words, it's good to have those seats. So they're upgraded. So what happens is Coach Switzer walks around, and he decides that he is going to relax and enjoy the beautiful Oklahoma sunshine about 10 rows behind the Platts in the stadium. It just so happens that the Platts say that George told his wife Linda that he had to go to New York the following week because TIC was going to buy the public shares of Phoenix. Coach Switzer then got up, got his friends together, and made $500,000, okay? And the deal was consummated as a merger. The SEC brought suit. The SEC said, Judge, this story is preposterous. This just can't be true. And what happened was that the judge believed the Platts and believed Coach Switzer, and under the law, there was no liability because the Platts did not tip for personal gain, because their testimony was they had no idea that Coach Switzer was sitting behind them. But yet, I don't know if Coach Switzer knew the difference between a merger or a tender offer. But if the deal had been structured as a tender offer, because tender offers happen with frequency, even in friendly deals in the U.S., he would have been clearly liable because the friendly deal would have been based upon, if it was a tender offer, based upon the parity of information approach. The Switzer knew the information was material and came from an insider. So therefore, this is an example in the U.S. of someone being able to keep $500,000 U.S. or otherwise being clearly liable and subject to, in fact, imprisonment if the deal had been structured as a tender offer. So that's utterly unacceptable. Here's another situation where we're dealing with the misappropriation theory, the Chessman decision. What happened there was that the Wadbaum grocery chain was a regional supermarket chain in the Northeast. What happened was that even though it was publicly held, the Wadbaum family, the founding family, still had a large percentage of the company's stock. One day, Ira comes home after work, and his wife Susan says to Ira, I need to take Mama into the city tomorrow, meaning New York City, because we need to get the stock certificates out of the safe deposit box because A&P is buying our company. A&P is a national, if not international, supermarket chain. Now, Ira, this is confidential. You're not to tell anyone. Yes, dear. Well, what happened was Ira went out, told his broker, bought some more stock. Okay? The government brings suit, goes to the Second Circuit. The government's theory was that Ira breached a fiduciary duty, a relationship of trust and confidence to his wife, who had entrusted him with information. That was the government's theory. The Second Circuit held that unless there is a practice of sharing confidential business information, the relationship of marriage is not a fiduciary relationship, a relationship of trust and confidence, and therefore no liability. So as I say, how it was viewed by the Second Circuit is that one has a close relationship with a director of a company in which that person owns 3 shares of stock than he or she has with one spouse. Of course, never having met that director. Now, that's bizarre. Now, the SEC took issue with that decision. And it adopted a rule called Rule 10b-5-2. And what Rule 10b-5-2 says is that there is a relationship of trust and confidence for purposes of the misappropriation theory in 3 situations. One, if there is an immediate family relationship, like parent-child, spouses, siblings, unless it is shown by the defendant that there is not a close relationship. Secondly, if there is a close friendship or significant other where there's a pattern of sharing confidential information, those 2 are not controversial. The third is that if there's an agreement to keep information confidential. And what the SEC has said is that a non-disclosure agreement is in fact actionable under Rule 10b-5-2. So in other words, you're representing a client who is going to sell its company to a prospective buyer. And the prospective buyer wants to do due diligence, what we may call in the U.S. kicking the tires. I'm not so sure it's referred to as that here, but that's a term that's used, kicking the tires, due diligence. Well, of course, what your client is going to insist upon is that prospective purchaser sign a non-disclosure agreement. And one of the reasons you have that agreement signed is because you don't trust that other party. And you want to make sure to have some sort of contractual remedy in case there's a breach. Well, what the SEC has done is to elevate this contractual situation to a relationship of trust and confidence, which is an entire fiction. So let me go over one of the cases. I do expert witness work. And have any of you heard of Mark Cuban? Well, Mr. Cuban, if you've seen Shark Tank, if that's ever shown here, he is one of the investors in Shark Tank. He was the former majority owner of the Dallas Mavericks, for those of you who are into NBA basketball. Luka Doncic, of course, plays for the Mavericks. He's not a shy person. Anyway, he owned 6% of a company, of all things, called Mama.com. And Mama.com was going to do what is called a PIPE transaction, a private investment in public equity. Is that done here? Okay, so he's going to do a PIPE transaction. It'll take me too long to explain what it is for purposes here. And what happened was Mr. Cuban was at a charity golf tournament, and he was rating the card, among with others, Michael Jordan. I imagine you all have heard of Michael Jordan, the great NBA player. So Mr. Cuban was in a good mood. He rode the cart. He didn't play golf himself. Maybe he had a few refreshments while he was driving the cart that day. And he came back to the American Airline Center, and he got a call from the CEO of Mama.com. And he said, Mark, I've got confidential information for you. Should I go ahead? And the CEO said, Mr. Cuban said, go ahead. And then he told Mr. Cuban that the company was going to engage in a PIPE transaction and whether Mr. Cuban wanted to take part in the transaction. Mr. Cuban said, allegedly, now I'm screwed, I can't sell, quote unquote. They then gave Mr. Cuban the phone number of the placement agent for the deal, a guy named Arnold Owen, and Mr. Cuban called Mr. Owen, and Mr. Owen told him about the deal some more. Mr. Cuban was on record as being very opposed to PIPE transactions because, in his view, they dilute the value of current shareholders' equity and the value of their shares, which is a strong argument. What happened then was Mr. Cuban then sold his shares and avoided roughly $750,000 worth of profits. Now, under Singapore law, if we agree the information is material, and that's an if, then clearly he would be liable because he learned this information from an inside source. What the SEC had to do was use Rule 10b-5-2, and that is that Mr. Cuban breached a duty to the source of the information. Well, there's no fiduciary duty that Mr. Cuban owed to the company. He was not a controlling shareholder. He was not privy to board decisions. He did not have access to internal corporate information. The argument was used was that he verbally said, okay, go ahead. And that's what the government's case was based upon. Mr. Cuban denied, what he did say was, I don't remember the conversation. He said, I walked into the American Airlines Museum, Airlines Center. That's where the Mavericks play basketball. That's where concerts are held. So, if you want to hear, Elton John or Rod Stewart or Bruce Springsteen, that's the kind of music I like. That's where they come to Dallas. That's where you go see them play. He said, but I'll tell you what, I've got my personal attorney, Robert Hart, who's a graduate of SMU School of Law, not this SMU in Singapore, but the SMU in Dallas. And by the way, for you students who are interested in getting a U.S. Master's of Law, think about coming to Dallas and think about coming to SMU. We have a very strong international law program. You'll love Dallas. It doesn't have the hassles of New York, doesn't have the issues of the West Coast, and it's a beautiful campus. It's been viewed, I think it was voted the second prettiest urban campus in the United States. It is a beautiful place. This is my 36th year at SMU. I say I began when I was 12, and it's been entirely enjoyable for me. And for those who don't know, Dallas has the third largest number of publicly held companies headquartered in that city in the United States, after New York and Los Angeles. So it's a tremendous city and growing and much more affordable than many other cities. So what happened here was the government argued that he breached a duty because he had a confidentiality agreement. Mr. Cuban said, I don't remember the conversation, but I would never orally agree to a confidential agreement. I have my SMU astute lawyer, Robert Hart, who I have look over any written non-disclosure agreement. And we discussed it at length before I ever am privy to inside information. In any event, the case was tried. He was found not liable. So let me So I think I've said enough for about the U.S. law. Let me just talk about some proposals that I have. This may take 5 minutes, if that's okay. Thank you. The U.S. securities laws are deficient from the standpoint that there is no requirement to disclose material information. If the information is not set forth in an SEC regulation, and the regulation is called Regulation SK, that is very detailed, and the company has not otherwise spoken on the issue, there is no obligation to disclose even material information. So that means a company can remain silent with respect to an adverse material fact, even though it is very important to the marketplace and to investors. I find that unacceptable. I think the U.S. law should be changed. And moreover, what it does is that it impels, it causes more improper insider trading. The longer that material information is embargoed and not disclosed, then of course the greater likelihood that people will take advantage of that opportunity. Studies have shown that countries which have a very short time period between when information is material and requiring disclosure have far less incidences of insider trading than countries that have far more expansive periods. That's number one. Number two is that insiders do not have to disclose their trades until 2 days after they trade. Well, we all know that when insiders trade, it may, not necessarily will, for sure, but it may well indicate that there is an important development. It may not be, quote, material, unquote, but of course, insiders know, officers and directors know far more information than we do about a company's prospects. That's why the market follows what officers and directors do with respect to their buying and selling. Well, I think that it would be far better for the marketplace if insiders had to disclose the day before they purchase or sell. So in other words, if directors and officers owe a fiduciary relationship to the company and its shareholders, why should they be at the front of the line? They are the first to take advantage of this information, and yet they are fiduciaries. In my view, there's no problem with them trading, in my view, if they're not trading on, quote, material information. But as fiduciaries, they should go to the back of the queue. So let them go ahead. For example, today is Thursday. They can file, and let's assume the market is still open, which it's not. So let's assume it's 2 o'clock today. They can go ahead and file the form with the Securities Authority that I intend to sell 10,000 shares at the opening of the market tomorrow. And they file that, and then they can sell the next day. I think that this would very much level the playing field. So that's another approach that I would recommend. And then I would recommend the adoption of the access approach. I personally like the access approach better than the parity of approach. And the access approach is that those individuals who, because of their relationship with the issuer, mainly directors, officers, employees, attorneys, bankers, auditors, by way of example, that these individuals have unequal access to material non-public information because of their relationship with the issuer, that they ought to be subject to the obligation to adhere to the insider trading laws. And their tippees who receive information having reason to know of those individuals' access should also be held accountable. But I believe that the parity approach is a bit too broad. In other words, that a person overhears information, that a person, a financial advisor, is able to piece aspects of non-material information, and through the mosaic approach, be able to compile material information, that arguably would be subject to the insider trading prohibition. So that's the approach that I would adopt. That's the approach adopted by some countries abroad, although the parity approach is the most prevalent here in the EU and Australia. And of course, I would prefer the parity approach over the current U.S. approach. So in conclusion, I want to thank you very much for being here. I'm honored to present in my first trip to this superb university, the law school of which is ranked #1 of all law schools in Asia. Congratulations on that superb standing. I go to Hong Kong University next week, and I'm sure that they will dispute that ranking. But nonetheless, the rankings are the rankings, and I'm just so delighted to be here, and thank you very much. Thank you.
I've just got some quick comments and maybe a very short question. With respect to rumors and non-public information, I think our position here is quite similar. We had a case called PP and Liu, where the court said that because the actual information is qualitatively still different from the rumor, because of that, it was still non-public information. Where materiality is concerned, I think you alluded to possibly the differences and the similarities in Singapore. We have, again, an interesting case called Madhavan, where the then Chief Justice said that when it comes to insider trading, the materiality test is one of trade sensitivity, in the sense it's not a causation test, rather than what a reasonable person would do with the information, whether he or she would trade. And he contrasted that with continuous disclosure, where it's price sensitivity, where you actually have to prove that this will affect the price. So in a sense, maybe it's true there's convergence in securities regulations across the world, because it leads us to the same position that you have, I think, that you're saying in America, where it is very hard to prove materiality in the context of continuous disclosure, but it's much easier to prove materiality in the context of insider trading. Now, I'm going to leave the more detailed questions to people from the floor, but I just got an existential, or a very general question, right? Because what's going on in Singapore now is that there are these reviews going on about how to revive the stock market, liquidity and volatility. So if there's an existential problem that may exist with stock markets around the world other than the US, and given how strong the US is, could it be that actually having a more restrictive approach to insider trading, i.e. the fiduciary approach, may well be the way to go? Because having too much regulation and strict insider trading laws may reduce the amount of activity in the markets, right? So I think that question we leave right to the end. But in the meantime, if anyone has any more specific questions on insider,
Would you like me to address that question?
Oh yeah, sure, if you want to.
Sure. I don't think it's the insider trading issue that is the issue. I think the disclosure issue. What is happening in the U.S. is that we have way more unicorns today. Those are companies with valuations of $1 billion or more that are privately held. The reason is that there's so much regulation. The Sarbanes-Oxley Act, the Dodd-Frank Act, executive remuneration. For me, if you provide me with a chart, if you explain in a page or two what executives are making, that's plenty good, as it is for most investors. If you look at a company's disclosure today, the executive compensation goes on for 30, 40 pages. And then you have the internal assessment of controls. You've got basically one requirement after another. In the meantime, what the SEC has done in the U.S. is to ease the ability of privately held companies to raise capital from investors who are, in fact, not all that sophisticated. So it has been the wrong approach. In other words, there have been more and more regulations imposed upon publicly held companies. And once the publicly held companies are in the system, they, of course, have their public investors, and they're basically stuck. But if a company is privately held, they see basically the burdens that are going to be imposed upon them, burdens as far as cost, burdens as far as short-term investors, and the result is that there are fewer companies that would go public than otherwise. So I'm in favor of stricter insider trading enforcement. I think the view of Singapore is the correct approach. I think where the problem in the U.S. has been is with basically the piling on the excessive disclosure requirements that are set forth, and that the ESG disclosure that some of you may be familiar with. I mean, if that in fact happens, which may not happen now, we're going to have another 30, 40 pages in the disclosure document, and that is simply excessive, and is another indicator why companies will shy away from going public and taking advantage of the public markets.
Thank you, Professor Steinberg. I'm Umakant from the law faculty here. I think, like you have pointed out, there's a lot of scholarship from the US and elsewhere about how, in many ways, the US regime on insider trading is problematic compared to other jurisdictions where it's a much more straightforward, whether it's the parity of information or access theory. But given that the whole US regime is based on like the 10b-5 anti-fraud kind of approach, why has there been no momentum from the US, either from Congress or from the SEC, to move to a more robust, straightforward, to some extent certain regime, as opposed to relying on a lot of these case laws and theories that have been moving kind of back and forth? So I was wondering whether there's any political economy or interest group explanation for why the situation is the way it is currently in the US.
If I understand your question correctly, it's why is the U.S. system overly complex and not basically amending statutes to make it more straightforward?
Yes.
Okay. Well, I don't know what the situation is here, but the political process in the United States is very challenging to get the Congress to focus on the issue and to have them address. And what happened since the Securities Acts were passed, at least since 1975, when there were major amendments, is that nearly every single amendment to the Securities Acts have been done in response to certain political events. For example, the Sarbanes-Oxley Act was the greatest federalization or regulation of the securities laws since 1934, and that occurred because of the financial debacles of Enron, WorldCom, and so on. The Dodd-Frank Act of 2012 was in response, 2010 was response to the financial crisis. On the other hand, you had legislation in 1995 that greatly restricted the ability of plaintiffs to bring class actions and private lawsuits. They still are going on in the U.S., but they're far more difficult today because in 1995, Congress got tired of the plaintiffs' lawyers bringing these cases and making these huge fees, and passed some very restrictive legislation, which President Clinton at the time vetoed, and this was the first presidential veto that Congress overrode. And then simply 2 years after Dodd-Frank was passed, Congress decided that it needed to enhance private capital formation and adopted an act that basically loosened the controls with respect to privately held companies unduly so. So what you have is basically haphazard legislation adopted because of the political climate without any real thinking of how the law should be. And there simply hasn't been the momentum to have the framework rethought. And since you asked that question, this will give me an opportunity to say that that's what I tried to do in my book, Rethinking Securities Law. So it's the first effort since the American Law Institute in 1980 thought about this issue. And what I did was I basically, as far as many of the key issues, I addressed what the law was or what the law is, what the problems are, and then how it should be remedied. That was what I tried to do in the book, and it has been well received. Has it had any impact on a practical level? So far, no. Am I surprised? Not at all. And I think it will only have an impact if there's another financial difficulty. Then it may have an impact. But as an academic, I think that you try to write on important issues and have an impact on policy. Whether you in fact succeed, of course, is beyond our control.
Okay, maybe belaboring the point a bit, Mark, but everything you say sort of, it doesn't contradict what we feel in Singapore, but there is, I mean, certainly a group that's looking at reviving the stock markets who would say that what you say about America being, the law's a bit uncertain, there's too much regulation with continuous disclosure, that the public markets are actually too small compared to the private markets because people don't want to do IPOs. That's exactly what they say of the Singapore markets, and we are hoping to learn from the American markets. And so the thing is, how is it that despite all these problems, right, with the regulation side, the markets are so strong? And I think that's what we're really trying to figure out here.
Right. Well, of course, I'm not an expert on Singapore law or Singapore. And it's a hard question. I could write a book on it. But a few thoughts. One is the public markets are very strong. The private markets, let me just step back for a second, to make this clear. The public markets are based upon disclosure. The securities laws and the SEC regulations set forth what information is required, and these regulations are quite extensive, so that professionals know what must be disclosed. The support is impressive in the U.S. markets. In other words, you have major corporations that have large in-house counsel, some of which are securities experts. You have many U.S. law firms, including in Dallas, that are very expert in securities law compliance and disclosure. You have an active plaintiffs bar that acts as a deterrent with respect to misconduct. You have an active SEC insofar as enforcement that even though the rules are not perfect, they nonetheless are sufficiently vibrant to give the SEC a very impressive enforcement presence. So in other words, as we know, the law can say whatever it may say, but if the law is not enforced, then there's going to be rampant violation. In the U.S., the laws could be better, such as with respect to insider trading, but nonetheless, the insider trading laws are relatively actively enforced in the U.S. It's very much a criminalized offense. The SEC brings many actions, and the U.S. Department of Justice brings many actions as well. And then we talk about going to the public markets. We have the investment banks, the underwriters. I mean, very strong. You talk about Morgan Stanley. You talk about Goldman Sachs, Merrill Lynch, UBS. Just many firms that provide a strong presence. You talk about the New York Stock Exchange and the NASDAQ. I mean, these are very strong markets. They're overseen by the Financial Industry Regulatory Authority, FINRA, which is a very strong presence. So there is active self-regulatory oversight that is in fact overseen by the SEC itself. So with respect to the public markets, I think there is a good amount of confidence in the integrity of the disclosure and with transparency. Not to say there's not fraud. Of course, there are lawsuits and there aren't problems. But overall, there's strong market oversight and investor confidence. What troubles me about the U.S. markets is that the private markets disclosure is a matter of negotiation between the investors and the issuer. And the theory is that voluntary disclosure will be sufficient and that no one is forcing these individuals to purchase the stock. My concern is that if normal human behavior prevails, insiders will be reluctant to disclose adverse information on a timely basis. And we really don't know the level of transparency with respect to these privately held companies. And that's my concern. Are these companies going to have a financial crisis at one point in time? I don't know. I hope it doesn't happen. but I'm concerned that there are the number of unicorns that are growing without any type of oversight other than fraud liability. And of course, once there's fraud liability, basically the money is lost. Of course, there'll be some compensation, but nonetheless, it's seeking to recover damages after the harm has been incurred.
Thanks, Mark. So I think that's the story that we're hearing. Although U.S. markets are, well, compared to Singapore, very highly valued, it might be the private equity markets are even more overvalued, right? And that's seriously, there might be dangers down that way. For us in Singapore, as you know, we've been talking about this in the last 6 months. We're trying to figure out a way to make the markets more vibrant. And it sounds like from what Mark is saying, we have to find that right balance between enough regulation, the right kinds of regulation. So even if maybe insider trading isn't as well regulated in the US on paper, right? The enforcement makes up for it. It's about finding the right balance, and I'm not sure it's going to be an easy task in Singapore, finding that balance. Some people think it's not a supply side problem, it's not about regulation, that's more about finding the investors to come in, but it sounds like it's a chicken and egg thing, and it's you have to get that tipping point where everything comes together, and it's not going to be easy. So it remains to thank Mark once again, unless you have something to say.
I want to congratulate you on your distinguished academic career. Very impressive. Congratulations.
Thank you once again.
Thank you.